Hello friends, my name is Dalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we'll be discussing certain important developments which has happened in the field of polity in last week. So we'll try to look at the static part related to it. We'll try to go through the news as well. And in the end, we'll have some practice questions. Okay, so let's start with the discussion. First, we'll be seeing the outline. We'll be discussing 5 topics today. One is 75 years of Supreme Court. Okay, so Supreme Court is celebrating 75th year of the establishment. Okay, then we'll be talking about the important you can say development which has happened in the Supreme Court, or you can say historical evolution we will try to look at. Then we will talk about the various constitutional factors. We'll try to look at the tenure, etc. We'll try to look at the important powers of the Supreme Court. Okay. Then moving further, the Aparajita anti-rape bill in West Bengal, you know that there was this �𝐀𝐒 hospital case, and after that there was this demand that there should be changes in the you can say anti-rape laws. So basically, considering that, the state government has come up with a bill. We'll be talking about the bill. We'll try to see that what are the existing provisions and then what are the you can say proposed provisions in that particular bill. Okay. Moving further, women quota in Rajasthan. Rajasthan has given 33% quota in the, you can say, police force for women. So we'll try to understand that why such quota is been given. And second thing, we'll be seeing that what are the, you can say, constitutional mandate which are talking about the quota or reservation for women in the, you can say, our system, political system. Then moving further, foreigners tribunal. The Foreigners Tribunal has been in news because there are nearly 28 people which has been relocated into or sent to the transit camps in Assam. So in that regard, this foreign tribunals has been in news. We will be talking about that. And then open jails in India. Supreme Court has made a regard, or you can say some statement regarding this. So we will be talking about that as well. Okay, so these are the 5 topics we will be discussing today. These are basically the 5 you can say development which are important development which has happened in the past week in the field of polity with respect to your current affairs. Okay, now let's start. First one is 75th or 75 years of the Supreme Court. Now on this particular occasion, they have, you can say, president has actually enrolled or came up with this particular flag of Supreme Court, different flag for Supreme Court which has been designed. Here you can see this is the, you can say, logo which has been used on this particular flag. Okay, here in the top it is written Supreme Court of India, and then here you can say this is the picture of Supreme Court. Here we have Ashok Chakra, and this is the constitution book. Okay, and here in the, you can say, bottom of this, yato dharma tato jaya. Okay, yato dharma tato jaya. So basically that is what has been written over here in this particular flag. Okay, so Ashok Chakra is there, Supreme Court buildings picture is there, and the book of constitution is there. That is how they have actually celebrated it. Now there are certain other things which has also been done. So let's see over here. Recently, President unveiled the new flag and insignia of the Supreme Court, established 26 January 1950 to mark 75th year of its establishment. Okay, so we are in the 75th year of the, you can say, establishment. Now the flag features Ashok Chakra, Supreme Court building, and the book of the Constitution, which we have already seen. Also, Prime Minister released a commemorative postage stamp celebrating 75th year of the you can say Supreme Court of India. So basically a postal stamp has also been released in this regard. So that is about the present development which has happened. Now we will be talking about the Supreme Court of India. Here you can say Supreme Court of India is the apex judicial body under the Constitution of India. That is true. Other than that, when we talk about the history, when we see the you can say various bill which were there to regulate in the British era. Okay, so we start with the 1773's Regulating Act. Okay, with that also comes the idea of Supreme Court. In that point of time, they have established a Supreme Court in Kolkata. Now this is not exactly how present day Supreme Court is with respect to the power, etc., but you can say somehow the concept has actually or the foundation has been laid at that point of time. Now this Supreme Court was there only for Calcutta. Okay, here you can say Regulating Act established the Supreme Court at Calcutta, that is 1773. So you know that we have a Regulating Act 1773 which is basically talking about a Supreme Court at Calcutta. Now following the suit, there were other Supreme Court which has been actually established in the other presidencies. Here you can say in Madras 1800, 1823 at Bombay. Now at this point of time, the all 3 important presidencies of you can say East India Company at that point of time had the Supreme Court. Okay, now come like 80 1861. You know that after 1857's revolution, we have come up with one act, that is 1858's act, okay, and then 1861. At that point of time, with this particular act of 1858, that was Queen's Proclamation, and with that the rule of East India Company was abolished, and then there was a direct crown rule which was there in India now. Okay, now with that they have come up with the idea of high courts. Okay, they have created high courts in these particular areas, and the concept of Supreme Courts over here was abolished. Okay, so here you can say High Courts Act created high courts, abolished the Supreme Court. Okay, so 1861, when the Queen took charge, they have come up with a new you can say concept of high court, and Supreme Courts were abolished. Okay, now 1935 we have come up with the Government of India Act. When we talk about this Government of India Act 1935, we know that there was this proposal that there will be a federation which will be established, and in that regard there was a federal court which was actually created at that point of time, that is Federal Court of India. Now essentially we can say that this is the predecessor of basically your Supreme Court. Okay, then in 1950s, when we got independence in 1947, and after that we have 3 years for to prepare the constitution, etc., and then in 1950 we have actually established the Supreme Court of India. Now that is the present Supreme Court of India, which has been, you can say, established in 1950. But the thing is, the idea, or you can say the predecessor of this particular court was Federal Court of India. Okay, before that, whatever courts were there, these were all kind of having powers related to high courts and not the essentially Supreme Court. Okay, so that is about it. Now we will be seeing that what happened after 1950s. Okay, so after 1950s there was this phase, that is 1950s to 1967. You know that at that point of time the government was mostly formed by Congress. Congress had a, you can say, very strong hold, you can say. Okay, so obviously the government was powerful at that point of time, so judiciary was showing some kind of restraint. Okay, so at that particular in that particular phase, that is from 1950s to 1967, at that point of time they have shown judicial restraint. They were actually just adhering to the constitutional text. Okay, they were focusing on the letter of the constitution. Okay, so they were conservative in their approach, and when we are talking about the ideological influences, they tried to avoid any kind of or supporting any kind of ideology. So that was the time period when you can say that Supreme Court was taking a restraint, or you can say judiciary was not very powerful. Okay, or you can say executive at that point of time having a sway. Okay, moving further, 1967 to 1976. Okay, now this is the time when judiciary was active. Okay, you must have seen the important cases like 𝐠𝐲 case, the Keshavanand Bharati case. All these cases were coming in that particular time. Okay, so in this particular time, 1967 to 1976, judiciary was quite active. This was the time of the judicial activism. Okay, moving further, you will be seeing that at that point of time there was various discussion with respect to the fundamental rights, and amendability of the fundamental rights were being discussed at that point of time. You know that there was this whole you can say series of cases which are there, Sankari Prasad, and then 𝐠𝐲 case, then again after that there were various cases, then you can say Keshavanand Bharati case. All these cases were talking about one thing, that whether fundamental rights can be, you can say, amended or not. Okay, finally with Keshavanand Bharati this debate ended, that they have created a basic structure. Now that basic structure is having you can say important when we are talking about the basic structure, Supreme Court of India is the authority which is deciding on the basic structure. Okay, so basically here Supreme Court, or the you can say courts, are having a sway over the executive. Okay, now here you can say, since they are accommodating more power, or they are having more power with respect to the constitution, so there was this confrontation with the parliament, because if there was this over activism which was there, that means that they might enter into the domain of legislature as well. That is why in this particular phase you can say there was this judicial activism. Then you know that 1976 there was this case, ADM Jabalpur case. In ADM Jabalpur case, it was seen that somehow government is having more influence than the judiciary. Here we have seen that judiciary was having an influence. At that point of time, we have come up with the ADM Jabalpur case, wherein the you can say the concept of seniority in the appointment of the Chief Justice was not followed. Okay, and there was a judge who has superseded 3 judges, senior most judges, and then he became the Chief Justice. So that was discussed in the ADM Jabalpur, and that was done by the government. Okay, so that was there. And now to overturn that, okay, and before that, you know that there was the time of you can say emergency as well. Okay, so that was overturned here in the third phase, that was 1978 to 2014. That was the time where you came up with the concept of public interest litigation, and there was again judicial activism. Okay, more and more PIL was quite famous at that point of time. Okay, is in this particular point of time, the right to life was expanded in various you can say arenas, or you can say various you can say interpretation has been taken with respect to right to life. The wider and wider, broader interpretation was taken by the court over here, and then they have come up with the idea of collegium. You know that was the point when we talk about the judges are appointing judges with respect to the collegium. It is often said that judges are basically appointing the judges. So here you can say that this was the time of judicial activism. Here judiciary was having a more you can say influence over the executive. So here you can say collegium and the right to life was expanded, so judiciary has the more power. Then fourth phase from 2014 to till now. Now here in this point of time, you must have seen that we have taken very liberal interpretations of the constitution. We have came up with the right to privacy. We have came up with the right to marry is also a right under right to life. We have come up with the right against the impacts of the climate change. So these are certain liberal interpretations which has been taken by the court. Okay, so this is the time where liberal interpretation has been taken, and this is the time which is basically talking about the judicial activism, which is still there. Okay, so these are the various phases. You can say that how Supreme Court has influenced, okay, the Indian polity. Now moving further, we will be talking about the composition. We have 34 judges including the CGI. So here you can say that 33 plus CGI which is there. And when we are talking about the appointment of these judges, that is done by president. But you know that we have a collegium system as well. Okay, we have discussed the collegium system in the previous lectures, so that is there. But the final appointment will be done by the president. Okay, but you can say that is on the consultation with the you can say Supreme Court. That consultation is basically has given rise to the establishment of the collegium. Okay, we have discussed that, so I will not be going into details of it. Now eligibility, if we talk about that, to become a judge of Supreme Court, so you need to be Indian citizen. You have to be a judge of High Court for 5 years, and or otherwise you can be an advocate for 10 years. Okay, or distinguished jurist in the eyes of president. Then tenure, if we see, 65 is the age of retirement. Okay, before that either you can resign or there can be a removal. Okay, now there is this word which is used, that impeached by president. Now generally we use this particular word that Supreme Court judges are impeached by the order of president, but the thing is, this is not exactly impeachment. This is kind of a impeachment like procedure. Okay, so salaries are determined by the parliament. Impeachment process, if we see, so removal is done by president, but there will be a parliament's approval with special majority which is to be done. Okay, so this is about the composition and you can say tenure and removal. Now if we talk about the jurisdiction, so there are different kind of jurisdiction which are there. One is your original jurisdiction. So if there is a dispute between center and state, between two states, or you can say center and several states, in that case there is the original jurisdiction. Direct these states can go to you can say Supreme Court. That is Article 131. Okay, then constitutional remedies, if we talk about Article 32, in case of violation of fundamental rights, you can directly approach the Supreme Court. That is constitutional remedies which are there. So that is Article 32. Then we have writ jurisdiction. Okay, so power to issue writ for enforcement of the fundamental rights, which is there in Article 139. When we talk about appeal, so we have appellate powers as well. So for the matters of the constitutional matters, civil matters, criminal matters, special leaves, etc., which are there in the constitution within these articles which are mentioned over here. For your you can say exam point of view, this special leave is quite important. Article 136, they have asked the questions about that. Then moving forward, there is this advisory jurisdiction as well. So president can ask for the advice. So there are presidential referrals which are there, and then they can ask for the advice. Okay, so that is there under Article 143. Now other powers, if we talk about, so there is this power to punish for contempt of the court. Okay, so that is Article 129. Okay, other than that we have Contempt of Court Act as well. Then Article 137, Supreme Court review its own judgment. It can review its own judgment. It can go for the higher bench and they can review the judgment. Moving further, Article 141, that is Supreme Court's decisions are binding to all court, because Supreme Court is a court of record. Okay, so that is there, which is given in Article 141. Article 142, if we talk about orders and decrees of the Supreme Court are enforceable. Then Article 147, this is talking about the ultimate power to interpret the Constitution. Supreme Court is the final interpreter of the Constitution, so that you have to remember Article 147. So this is also important for you. Now this is all we have talked about Supreme Court. Okay, if you see here, there are certain terms that acting Chief Justice, ad hoc judges and retired judges. You can go through this particular slide, who is basically appointing them. Okay, so when we are talking about the acting Chief Justice, President will be appointing it. Ad hoc judges, if we talk about, so that will be appointed temporarily by the CGI for quorum issues. Okay, so when we are talking about the quorum, in Parliament we have a quorum, and in Supreme Court also we have a quorum. Minimum number of judges should be there. So that is there. And retired judges, okay, Chief Justice can reappoint a retired judge temporarily. So in the case of ad hoc judges and the retired judges, since these are daily processes, so here you can say CGI will take a decision, and acting Chief Justice, okay, so in that case President will take the decision. Okay, I hope that is clear. Now we can move to the next point, that is basically Aparajita Woman and Child West Bengal Criminal Law Amendment Bill 2024. Okay, because of the issues which are going on in Bengal, there are various you can say heinous crimes which are committed against women all across the country, or you can say at the world level as well. But state of Bengal has actually come up with a bill where they have actually made some changes in the existing bills. Okay, so when we are talking about the BNSS, Bharatiya Nagarik Suraksha Sanhita, and we have POXO Act, etc., so they have made certain changes in that. Okay, so we'll try to understand these changes. Okay, we will see. Now West Bengal Assembly passes a bill on rape by voice vote. Object is to create a better ecosystem for the safety of women in the state. That is something which is very simple. The name of the bill is the Aparajita Women and Children West Bengal Criminal Law Amendment Bill 2024. The bill amends relevant sections of the BNSS and POXO. Okay, so when we are talking about BNSS, this is your Bharatiya Nagarik Suraksha Sanhita. This is in place of CRPC right now. Okay, and when we are talking about the POXO Act, so that is prevention of child prevention of the whatever sexual offenses are committed on the child. Okay, so that is coming under the POXO Act, that is being taken care in the POXO Act. Now three major components are there in the bill. One is that they have increased the punishment. Okay, now increased punishment for various crimes, that is given in the bill. Second is speedy trials. Okay, so to make sure that the you can say a victim gets justice over here, so we have actually gone for the speedy trial, and we are looking at the you can say making sure that investigation is done within 21 days. So that is one thing. Other than that, speedy justice, speediest verdict. Okay, with respect to the investigation, that is there, that we go to the trial as early as possible, and then speedy verdict can also be done over here. That is also one factor which has been considered over here, that the judges has to give the verdict as soon as possible. Okay, other than that, they will be going for the Aparajita task force. Now this task force will be there to prevent these crimes against women. Other than that, if there is a crime, then they will be the you can say going for the investigation, etc. Okay, now this is the broader aspect. Now if we talk about whatever the changes which has been done, so when we are talking about the current BNSS you can say sections, so here you can see 64 clause 1, this is talking about rape. Okay, right now the punishment is 10 years of rigorous imprisonment that can extend to life and fine. Okay, so that is one thing. Now the proposed one is rigorous imprisonment for life or death. Okay, coming to the second one, rape by police officer or public servant. In that case, onus is even more high, because these are the you can say officers who are supposed to prevent such things from happening. So that is there. Here 10 years of rigorous imprisonment that may extend to life and fine, that is the existing provision. Now in the proposed bill, it is rigorous imprisonment for life and fine or death. Okay, so here also you can see that they have gone for the rigorous imprisonment plus fine or death. Okay, moving further, rape that causes death or persistent vegetative state. Okay, so in that case 20 years of regressive imprisonment that may extend to life or death, that is the existing provision, and in the proposed one they have directly mentioned punishment as death. Okay, so in case if a victim is subjected to death or any kind of vegetative state, in that case there will be a provision of death. Okay, moving further, in the cases of gang rape, 20 years rigorous imprisonment that may extend to life and fine. Here rigorous imprisonment for life or death. Then repeated offenders, for that also they have proposed that there should be rigorous imprisonment for life or death. Okay, so these are certain things which has been proposed in the, you can say, the current bill. Okay, for POXO it only provides the life imprisonment or death sentence for penetrative sexual assaults. Okay, so that is about these changes which has been mentioned. Now the thing is, this particular bill is not yet implemented because it is a bill, because it has been passed by the state assembly, but yet it is to receive the presidential assent. Okay, when we are talking about the presidential assent which is not yet been given, so that is why it is not yet an act. Now when we are talking about the previous you can say Supreme Court judgment, etc., so there is this Mithu versus State of Punjab case 1983. In that case Supreme Court ruled that mandatory death sentence violates the fundamental rights. Okay, so here you can say, if that is the provision which is there, that there is the mandatory death provision is given, so here they are saying that that is against the fundamental right, that is violating fundamental rights of equality before law, article 14 and article 21. Okay, would result in unfair, unjust and unreasonable procedure that can deprive a person of his or her life. Okay, so that was the judgment which was given by Supreme Court in 1983. Now coming to the part wherein should that be an act or not, that is depending on the presidential assent. There are similar cases wherein similar laws has been passed in Andhra Pradesh and Maharashtra as well, so they could not get the presidential assent. So till now we are saying that we have to wait whether it gets the assent or not. Now criminal laws falls under the concurrent list of Indian Constitution, meaning both state and central government can go for the legislation over there. However, state laws require the presidential approval to take precedence over the central law. Since we already have a central law, that is BNS, which is there, so already existing central law is there, and if you want to make any change, then in that case you have to take a presidential assent. We have discussed this power of presidential assent, etc., in the previous lectures as well. Okay, so we will not go into details of it. Now moving further to the next one, that is Rajasthan 33% quota for women in the police force. Okay, so that is a progressive step which has been taken by Rajasthan. Now why it is necessary? Because of the various heinous crimes which are happening against women and child, that is necessary that the number of female officers increased in the you can say police force. Considering that, Rajasthan has come up with this particular, you can say, approval by the cabinet. Now our you can say objective over here is to see what is the role or what is the status of women in the police force as of now. We will see what are the steps which has been taken. Okay, now let's see need for women in police force. That is one thing we have to address here. If we are talking about the 2022's data, women made up to 12% of the state police. Okay, out of, you can say, all police force, you can say, resources what we have, only 12% are female. Okay, so that is a cause of concern as of now. Second thing is Chandigarh has the highest, that is 22%, and Jammu and Kashmir has the lowest, that is nearly 3.3%. Okay, so that is the condition of female in the police force, and that is one of the reasons that we have to increase it. Now legal mandate, if we are talking about, there are certain acts which provides that there should be a female officer, with respect to that particular case. So when we are talking about the POXO Act, okay, when we are talking about any kind of sexual offenses which are happening against the children, in that case, and major criminal laws now are required every case of sexual assault to be recorded and investigated by a female police officer. So that is a legal mandate, that is a legal requirement which is there. Okay, then arrest of a woman and searching of a woman must be done by a woman only. Okay, so that is also one provision which is there, and because of which we need female officers in the, you can say, police force. Now better reporting of crime against women, presence of a woman can foster trust among the female victims, encouraging them to report a crime. So that is one thing. Improved police community relations, this is because a woman's use of excessive force is less common. So that is when we are talking about the Indian police, there is this perception that police officers are going for various harsh actions against the victim, against the accused. In that case, there are certain reluctance which is there. When we are talking about the female officer, it is known that they will use lesser force. Okay, so for that also, if we see, there can be improved police community interactions. Okay, so for that we need more women in the police force. Now challenges, if we talk about, now you must have heard about the you can say white collar jobs. You must have heard about the pink jobs. Now these are certain stereotypes which has been built. Okay, when we talk about any job, let's say engineering, etc., there are certain stereotypes that women are not much into mechanical engineering or civil engineering. Now this is just because there is this stereotype that they cannot go for the more and more physical works, etc. Okay, so these stereotypes are basically, you know, acting as an hurdle in their development. So that is one thing, stereotype. Women are seen to be unfit for long and unpredictable hours of police system. So that is just a perception which has been made. That is not true. Again, I'm telling you, this is just a stereotype which has been made. Okay, second thing is policy gaps. Absence of the reservation policy in many states. Police is a state subject, and under 7th schedule of the constitution, if we talk about, so that is a state subject. So there are various states which are not providing such provisions. If at all they have the provision, then implementation is very poor. Okay, next is implementation gap. First thing, we don't have the policy. If at all if we have the policy, then there is this problem of implementation. Okay, so Bihar has 35% reservation, but actually if you see, there are only 17.4% of female participation in the police force. Okay, so these are certain gaps because of which female are not being able to participate in the, you can say, police forces. Now if we talk about the initiatives which has been taken by the government, so you know that we have various reservations which are there for women. Okay, I would say affirmative action. Okay, affirmative action, when we talk about the article 15, article 16, these are certain articles which are talking about the affirmative action in the favor of women. That is one thing. Other than that, you must have heard about the 73rd and 74th constitutional amendment acts. Okay, now these are talking about the you can say local self government, and in that we have the reservation, 50% reservation is given in the panchayat. Okay, so that is there with respect to the women's reservation that has been given. Other than that, also here you will be seeing that Ministry of Home Affairs is issued as advisories to all states and UTs to establish at least one all woman police station in each district. That is one initiative which has been taken. Second is Article 243D of the Constitution has a provision for the reservation of seats for SC, ST and women in panchayats. We have already seen 73rd and 74th amendment. Then Ministry of Home Affairs issued advisory to all states and UTs to increase the representation of women to at least 33% of the total strength. That is one advisory which has been given by the you can say Ministry of Home Affairs. Then crèche facilities should be there, daycare centers should be there for those who are employed in the police force. And then all female candidates are exempted from payment of application fee in CAPF examination to increase the participation, to, you know, incentivize females to go for the, you can say, entry into CAPFs, etc. So such a step has been taken. Now these are the initiatives which has been taken by the government. Now this is about the reservation, or you can say some kind of affirmative action in the favor of women in various states, and Rajasthan has done recently 33% you can say quota for the women participation in the police force. Now talking about the next article, which is talking about your foreigners tribunal. Recently 28 of you can say Assamese people, they have been actually removed from their areas and they have sent to the transit camps. Okay, now who takes the decision on this particular person's citizenship? That is foreigners tribunal. If whether a person is a citizen of India or not, foreigner tribunal has the power to decide on that. In that course, there are 28% who has been sent to the transit camp. That was the news, and because of which we are talking about the foreigners tribunal. Okay, now let's see. Now these are quasi judicial bodies. Quasi judicial because these are not courts, but they are taking decision. Okay, so they are actually examining the evidences. So that is why they are quasi judicial bodies established under the Foreigners Tribunal Act Order 1964. Okay, so that is one thing. Now determines if a person residing in India is a foreigner or not. Okay, now they will be seeing that if a person who is residing in India, whether he is a foreigner or not. Now initially specific to Assam, you know that we have come up with the Assam Accord, and there was this provision with respect to the NCR. Okay, so for Assam that provision was there, and initially that these foreigners tribunal were created for Assam, and now there, after 2019 amendment, this was made that it was made sure that every district has them. Okay, so now applicable to nationwide post 2019 amendment. Now foreigners tribunals are established to enable state administration, district collector, district magistrate to make reference about a person suspected of being a foreigner to the tribunal. Now these the state administrative authorities, they will basically, if they suspect that some person is a foreigner, they will make a reference to the foreigners tribunal and they will decide on the matter. Okay, now constitution and power, if we talk about how many members should be there and what are the powers they have. So if we talk about the composition, individuals with the judicial experience, that is you can say kind of eligibility. Then talking about the membership, there can be you can say one member and there can be multiple as well. Okay, in case of one member, that he is the only person, so you don't have to have a chairman. But if there are multiple you can say members are there in the tribunal, in that case one among them will be acting as a chairman. Okay, now moving further, power of tribunals if we talk about, so power of tribunals are similar to the power of civil courts. Okay, because they are also deciding on a matter whether a person is foreigner or not. In that case they will have similar power to the civil court under the CRPC. Okay, now since we have actually changed it to you can say 3 other Sahitas, so accordingly we will see over here. Okay, but summoning and enforcing the attendance of any person, they can summon and ask for attendance of a person in a particular case and examine them. Second thing is requiring the discovery and the production of any document they can ask for you to produce in that particular tribunal. Then issuing commission for the examination by any witness. Okay, so these are certain powers which are there with the foreigners tribunal. Moving further, recent amendment if we are talking about, so as I told you that earlier it was applicable to Assam only, but the recently it has been made applicable to all over India. Now it empowers district magistrate to establish the tribunals. Okay, earlier central government had the power. Second is provides procedure for tribunal to handle appeals related to NRC claims and objections. Okay, since Assam had the NRC provisions etc., so in that case if someone is not happy with that and they want to go for appeal, then they will be going for the appeal in the foreigners tribunal. Moving further, key changes if we talk about, so district magistrate can seek tribunal's opinion on whether a applicant is a foreigner or not. That is one thing. Second is individual access. Individuals can now approach the tribunal. Earlier only state administration can go and ask whether this particular person is a foreigner or not. Now individuals can do that too. Okay, then next is current use mainly operational in Assam, but other states use local courts for the similar purpose. Okay, so that is about your foreigners tribunal. As of now we have certain concerns with respect to the foreigners tribunals. So here, failure of authorities, lack of appearance by the issuing authorities can lead to unjust foreigners labor. Okay, now if you can say a person, or if the you can say members of the tribunal are not taking it seriously, okay, or they are not examining the evidence seriously, then there can be unjust you can say label which can be there for a foreigner. Then talking about judicial delays, long delays in case resolution with some pending for years. Okay, there was this incident when there was one person who actually died when he got the citizenship. Okay, so that is the case, judicial delays can happen. Then implications of NRC, increased tribunal workload due to high members of NRC exclusion. Okay, so that is one thing, workload has increased. Burden of proof, individual must prove their non-foreigner status with extensive documentation. Now burden of proof is on the individual on whom there is this accusation that he is not a you can say citizen. So he has to prove that he is a citizen of country, he has to produce the evidences. Okay, so these are certain key concerns with respect to the foreigners tribunal. So we have talked about the foreigners tribunal in you can say in a comprehensive way, that must be enough for you to understand the concept of foreigners tribunals. Now talking about the open jails in India, as I told you, Supreme Court has made a remark regarding this, and that is why we have taken this particular article. Why is Supreme Court focusing on the open prison? Now obviously we know that we have this overcrowding in the prisons, and that is a cause of concern. Under trials are also there in the prisons, and if we are talking about these under trials, if they are living in that particular area for a long time, there is this social stigma which are also there. Considering that, Supreme Court has come up with this particular idea. No doubt that idea was there in 1980s also, we can say that there was this idea, but right now we can say that there are certain things to address them. Supreme Court has come up with the idea, and they have said that to focus on the, you can say more and more you can say regulation and administration, or the you can say progressive changes in this particular system. Addressing overcrowding, open prisoners could help alleviate the issue of overcrowding in traditional prisons. Okay, in the traditional prison cells there are particular capacities, but they are 3 times overcrowded in India. Okay, so that is one thing. Second thing is psychological benefits. Now if first thing, when we are talking about this overcrowding, if there are open prisons, they do not have to be in the cell, they can actually roam around in the campus. Okay, so that can be a helpful thing in addressing the overcrowding. Now psychological benefits, these facilities are intended to reduce the stress of reintegration for the convicts. Now if a person is living in the solitude inside a cell, then he might have trouble while connecting with the mainstream again. So that is why they are emphasizing on the, you can say, open cells, so that the psychological factor of solitude did not come into a person's mind, does not come into a person's mind. Okay, compliance and rights. Courts are also actually considering the human rights over here. So here you can say courts want to ensure that the states are implementing and managing these facilities effectively as part of their broader mandate to oversee prisoners' right over here. Okay, and prison management. So this is why Supreme Court is focusing on the open prisons. What are open prisons? Okay, with the name it is clear that when we are talking about the open prisons, we don't have the cell, we don't have this wired enclosures, etc. So here you can say facilities without high walls, barbed wires, emphasizing self-discipline and the community engagement. Okay, so one thing is that there will be self-disciplining factor. Second thing is community engagement will be there, so that there is no stigma. Second thing is they will be easily going back to the mainstream societies. Now, first open prison in India was established in 1905, evolving over time, focus on the rehabilitation. Mostly the focus is basically rehabilitation or the reforms. Okay, moving further, eligibility, it is eligible for all. There is this on the basis of good conduct and good behavior, you will be getting that. Okay, second thing is legal framework. When we are talking about what is the law which is actually taking care of such things, that is Prison Act 1894. Okay, international perspective, if we talk about, there are various global examples. Open prisons have been used in the Switzerland, UK for decades, and then UN recommendation, it advocates for the open prison system to support the rehabilitations. Okay, so these are the certain things when we are talking about the UN recommendations, etc. You can mention examples like Switzerland and the UK in your answer writings. Okay, now there are certain advantages. Okay, that is one thing, it is cost effective, or efficiency is there, reduce operational cost significantly. Okay, now if you have to maintain a prison, okay, if you have to maintain a campus, that will be a little bit difficult. Now these are open prisons, okay, and society is also contributing, so that is cost effective. Overcrowding issue will also be, you can say, taken care of, because you don't have to be in a congested environment over there. Second is psychological impact. As I told you that these people are going through a stigma, they are going through a burden, that how they will integrate into the society again. So that will be taken care, because since they are having these community engagements and they are in the open prisons. Then if there is a cell, there should be a staff to maintain that particular cell. If there is a cell, you have to make sure that nothing goes wrong inside that particular cell. When you are talking about a particular, let's say there are some 10 compartments in a particular prison, and you have to make sure that there are 10 people to oversee each compartment. Okay, but if there is an open prison, so you can have a, you can say, supervisory position from at the top of a building, etc. So that staffing requirement will also reduce. Rehabilitation will be the focus. Okay, then employment, increase the self-sufficiency. You can actually go for the prison employment. You know that Bihar has this particular brand name, that is Mukti. Mukti is a brand, or you can say Mukti Bazar is a brand which has been created in the Bihar's prison. Okay, so prisoners there, inmates there, are basically creating stuff over there, and that is sold in the market. Okay, so that is something which can be done. Socialization will be done, as there is this community engagement which is there. Reformative potential is there, community impacts will be there. So all these are the advantages of the open prisons. Okay, so I hope that is clear. Now after this discussion, we will be talking about certain questions which you have to attempt and answer to me in the comment box. Okay, so the first question is, which elements are featured on the new flag of the Supreme Court of India, you can say, unveiled by the president? Okay, options are Ashok Chakra, Supreme Court building and the book of the Constitution of India, national flag, Ashok Chakra and the Supreme Court building, Indian Parliament, Ashok Chakra and a book of laws, Ashok Chakra, a gavel and a book of legal codes. Okay, so basically you have to choose the correct answer. Moving further, what did the Supreme Court rule in the Mithu versus State of Punjab case 1983 about the mandatory death sentence? It is constitutional and necessary. It violates fundamental right and results in unfair procedure. It is necessary deterrent for serious crime. It should be applied only in case of terrorism. Okay, so I hope that is clear. You can answer this. Question number 3, what recent policy did Rajasthan government approve regarding the police force? 25% reservation for women, 33% reservation for women, 50% reservation for women, and 40% reservation for women. Okay, easy question. Now moving further, question number 4, what is the primary function of the Foreigners Tribunal in India? To determine nationality of a foreign national, to decide whether an individual is foreigner or an Indian citizen, to process visa application for foreigners, to grant asylum to refugees. Okay, so you can go through this options and answer to me in the comment box. Now the last one, which is question number 5, Which act governs prison in India? The Prison Act 1900, the Prison Act 1950, Prison Act 1894, Prison Reforms Act 1980. Okay, so you can attempt these questions. You can answer to me in the comment box. Okay, with that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.